Hey guys, let's do a case update on Sarah Boone. In the weekly docket, I showed Sarah Boone's latest letter to the judge and figured that didn't look good for the trial calendar, and by the time I finished the video, I was able to edit in the notice the trial had been delayed. Today, let's look at what happened in the hearing, though. It wasn't the letter that was the problem. It was the issue with the Battered Spouse Syndrome defense she wants to put on. The state reported they were ready to go, but the defense, no.
State's ready, Your Honor.
Mr. Bankwitz, where do you stand in regards to preparing for trial?
The defense is not ready. We're requesting a continuance.
Now, Sarah is butthurt at how long it's taken to get the trial, but the state is ready, and it's her side that's dragging. And they're dragging on the issue of prepping to present the battered spouse syndrome. The judge questioned the defense on, hey, what's the problem? The attorney said he talked to 3 experts who did not want to work for state rates, he said, and even tried to get a doctor associated with a battered women's shelter on board. But then he gave, I think, the bestest, most honesty answer: reluctance to testify. They didn't want to testify. He says that's because of notoriety, but I think that's putting lipstick on a pig here.
How deeply have you plumbed the depths of the pool of experts in this field to find out or find one who's willing to work for the JAC rate?
Well, I've actually talked to 3, and they don't have contracts with JAC and are not willing to work with JAC. And I've made some other inroads with battered women's shelters, trying to get their psychologists, who'd be willing. Problem is willing to testify, basically.
Okay. Because of the concern about the compensation rate for testimony?
Well, that's one of the things. And to be honest with you, this case has had so much notoriety that people don't want to be involved.
Okay.
Nobody wants to swear in and testify that Sarah was suffering from battered spouse syndrome at the time she drunkenly zipped up her boyfriend in a suitcase and then watched him try to get out for hours while he begged and said he couldn't breathe. She even videoed it, laughed at him, and went to sleep, and then he died while she was asleep. Now, battered spouse syndrome has different contours and uses in different jurisdictions. In Florida, you can argue mitigation with it, but you can also use it to support the traditional complete defense of self-defense. Normally, you have to show you reasonably believed that you were under threat of serious bodily harm or injury and that you used force proportional to the threat. Plus, you didn't have a duty to retreat or whatever. Not an issue here. Well, now that's easy if the spouse is beating you with a deadly weapon or shooting at you or something terrible like that. But what if the spouse isn't doing anything to you at the moment or even threatening you, and then you kill him? Oops, that's trouble. Battered spouse syndrome in Florida can be used to show that you were reasonably in fear of imminent bodily harm or death due to conduct that puts you in that mindset. So it can be used to get you off completely. So it sounds to me like they can't find an expert so clown-like that they can say with a straight face that she was suffering from this syndrome at the time the victim died. And people, this is Florida we're talking about. The idea that an expert won't testify due to notoriety of a case is, of course, ridiculous. Have you seen America? Have you seen this planet? The fact one hasn't crawled out from under a rock to cash a check simply for parroting this defense when it clearly isn't applicable, well, it almost brings a tear to my eye that maybe there's some hope for humanity after all. I mean, come on. First, there's the issue she told police they were playing a game, hide and seek, and it was an accident. No fear mentioned. Second, she's on video mocking him. Third, on the video, he isn't threatening her. So the concept that she's in such deep fear that killing him was her only option, it's obviously lacking from that evidence. But think, people, think. In a classic case, the abused spouse, say, shoots or kills the larger, stronger, threatening abuser. Maybe to poison him or stab him or something when they get the chance. The only path to safety, they feel, is to stop the abuser. That's what the whole syndrome is about. They're powerless. They're helpless, except for if they get one chance to stop this person. It's not an easy defense, but it's an understandable defense. Here, she did not intentionally kill the guy, she says, and it doesn't look like it. Under the state's theory and what she said in interrogation, she engaged in reckless conduct that led to his death. Can battered spouse syndrome even apply to reckless conduct like this? You're not intentionally defending yourself from a current or remote threat. You're just doing something dumb. Here, she didn't shoot, stab, poison, or otherwise certainly end the threat. She left him in a suitcase and went to sleep. If she were in such terror that killing her boyfriend were the only way out, how could she comfortably go to sleep knowing he might get out of the suitcase? And having begged to be released and being only laughed at by her, he'd be a bigger, more dangerous threat than ever before. And she's up there snoring. It's dumb. Now, granted, if you can get it to the jury, there's always the hope there's an absolute idiot who buys what you're selling. We are a species who spent money on pet rocks and collectible Beanie Babies, so I can't say that strategy is without merit. But for whatever reason, juries are not generally as absolutely stupid as the average social media user seems to be, and emphasis on average. I mean, jurors get 12 people often to say the same reasonable verdict based on evidence. But when have you seen 12 comments in a row on social media that didn't contain at least one drooling idiot? Maybe the jury panel selection algorithm has found a way to weed out basement dwellers. Coming back to the hearing, the judge said, hey, look, I get you want to put out this defense, but we can't delay this forever if you can't find someone to pitch it. He said she's entitled to an adequate defense, not every single defense she might want.
What I'm not sure about is whether the inability to find an expert forever delays the trial of the case.
I wouldn't expect it to be a forever delay, Judge. And you know me better than that.
Mr. Cacciatore, well, I just want to make sure everyone in the room understood that, I'll give reasonable amounts of time to prepare a defense. The defendant's entitled to an adequate defense, but they're not necessarily entitled to the exact defense they would prefer to have if resources were unlimited. So.
That triggered off social media to shake their heads, SMH, and decry the separation of rich and poor. Alec Murdaugh spent over $500,000 on just trial expenses, not attorney's fees. And the shining moment of that was his tiny ninja theory. And he's in jail. So yeah, if you have a lot of money, you can come up with all kinds of things. It doesn't mean it works. But I hardly think that's a reason to bankrupt the country, giving people an absolute blank check to hire an army of experts to pitch any theory they can think of to a jury because every once in a while somebody rich gets accused of murder and does it. Yeah, I mean, I agree. If you have enough money, somebody would fly in from somewhere and say she clearly was terrified as she went to sleep while he begged for his life. Sadly, she doesn't have that money. But if she did, any reasonable jury would side-eye that expert until the judge finally said, you're excused. The only good advice here, I guess, is don't videotape yourself watching someone trapped and struggling for breath after you put them in that situation, taunt them, video it, and then go to sleep while they die. And that really kind of avoids the whole problem in the first place. Now, if Sarah's team does find a clown expert to say that she was terrified, the state has the chance then to have an expert also evaluate her to see if they agree with that assessment.
Would you agree that if, in fact, you retain an expert and they're going to opine specifically on Ms. Boone's state of mind at the time of the incident, that opens the door for the state to also have an expert? All right.
Most definitely.
Perhaps being an optimist on expert integrity and morals, the judge asked each side to project the trial time as if no such clown expert were going to show up.
Let's say that turns out not to be an issue. We're not going to have two experts. How long would it otherwise take you to present your case? And Mr. Bankowitz, other than this potential defense, if we picked a jury in one day, the state presented their case in 2.5 days, how long do you anticipate a defense presentation would be at this point?
I'd say at least 3 days.
So it ain't his first rodeo, and maybe he thinks nobody's coming to do this. Nobody wants to swear in and say this in fear that lightning may penetrate however many floors of the building they're in and actually strike them on the witness stand. But the defense attorney said, listen, we want someone to testify about battered spouse syndrome and evaluate Sarah and show how it applied in her case. The judge is giving them additional time to do that, and the state to have her evaluated if she does come up with that. So her trial gets put off a little longer. She may need to get her writing hand strong again and write another letter about how she's upset with this, but it's her own decision to present this defense, right? She could go on to trial and say whatever she wants to say, but she wants battered spouse syndrome in this case where she zipped up a guy in a suitcase, left him there, taunted him on video, went to sleep, woke up, he's dead. She calls her ex-husband first, then finally calls the police. And she tried saying it was an accident. How horrible was it she'd have to live with this for the rest of her life? Finds herself in jail, and now she's a battered spouse because what else has she got left to say about this situation? So, case put off for a while, and we will see what happens next. Wouldn't write off another continuance, but maybe it'll actually get to trial this time. That's it. Thanks. Bye.